prefer to call the crystal ball session. I know it says best practices, but really what it is a crystal ball session. Ultimately, where we are right now is we've got a lot of new opportunities, new rules, and a lot of gray areas. So how do we manage them without going out of business? Best practices. I have an amazing panel for you all today that cover every step along the way in the process. We've got securities counsel, we've got immigration counsel, we have people who are selling the projects in the market, we even have bankers. So, and I don't want to leave out our financial person because I did promise you the cliffhanger today. So without further ado, let our panelists introduce themselves quickly. Some of them you've already seen today, some you have not. So let's start here with John Baker.
Hello, everyone, and welcome to the afternoon session. My name is John Baker, and I'm the Chief Marketing Officer of LCR Capital. We're a private investment and advisory services firm. We raise EB-5 capital, as you'd expect, for projects with developers. We also have an SEC-registered wealth management firm. That firm is also sponsors private equity raises, and is, for example, the manager of a US access fund. We work a bit with the Portuguese Golden Visa, and we have a business which provides international loans, often EB-5 backed loans, to foreign nationals interested in moving to the US. Frequently, that's to buy property or to free up capital to support other projects. I think the one thing I would also leave with you is that we're a very global firm with teams in India, Brazil, Dubai, Singapore, and we cover and speak all the languages around the world in order to meet investors directly and bring them into our projects.
Thanks, John. How about you, James?
So good afternoon, everyone. My name is James Sozomenou. I work with Signature Bank at New York City, soon to be down here in Florida as well, but for the most part out of New York. That's a little bit of information for you guys down here. So we've been in the EB-5 space about 11 or 12 years now. We've done billions and billions of dollars of this money. We've done projects as an escrow agent, as little as one direct investor, all the way up to projects raising just shy of $1 billion. So we used to say we see a little bit of everything. We actually see a lot of everything, all different asset classes, anything complex you could possibly imagine we've seen come through the bank. A lot of faces here, very familiar. We have a great relationship with a lot of the regional centers, attorneys, fund administrators that are in this space. And if we're not working together yet, I hope we can do it soon.
Thanks, James. Ron, go ahead.
I'm Ron Klasko, and nothing has changed in my biography in the last 3 hours. But I would like to take the opportunity to thank my friends at Saul, Ewing, and JTC for inviting me today. Thank you.
Thank you for that. How about you, Jay?
Jay Rosen, corporate securities attorney and partner at Saul Ewing, one of the co-hosts here. And on behalf of Saul Ewing and JTC, you're welcome, Ron. And thanks everybody for coming. It's a great crowd.
And last but not least, David Appel.
Thank you. I just want to also thank Saul Ewing for being on this wonderful event. My name is David Appel. I am a tax partner. I'm head of tax for the Southeast region for the Marcum LLP CPA firm. Proud to announce that we actually hit over 1 billion in revenue right now. We're the nation's 11th largest CPA firm. We actually have numbers of offices in mainland China. So hopefully insight on some tax and financial reporting issues.
Excellent. Thanks, everyone. While we're on the gratitude train, I do want to add my own thanks to all the panelists and the moderators that have come earlier in the day. Thank you for teeing up pretty much everything I wanted to talk about. So let's just follow through on some of that and put a nice bow on it so you all have some direction on where to go after today's session. Let's start with John. We got the RIA, new rules are passed, and we heard Ali say this morning, EB-5 is back in business. How easy is that?
Well, I think we all saw the passage and jumped for joy, and then saw the 60-day delay and paused, and then realized the legal challenges. But to say that we're back in business now, I think is very true. Everyone who's raising capital in the room is seeing investors file. And, at the end of the day, helping investors place the capital, create the jobs, that's what we're in the business of, in the case of our EB-5 projects. But I think we also have to recognize we're still at the beginning of that. And I think for this panel, being about best practices, it's important to recognize there's a lot of things still to be worked out. How do we market our projects? How do we work with promoters? How do we handle the audits? So all of that, I think we're going to touch on. But yes, we are definitely back in business.
We are, and that's a great segue. Jay Rosen. So if folks like John Baker out in the market and they're finding investors, how are you putting together an offering package?
I think that if there was a lot of care and attention putting together an offering package before the RIA, now there's even so much more so now that we're in this kind of brave new world with a lot of disclosure requirements, transparency, consistency issues. There's been a lot of talk about that on some panels today. And so putting together an offering package, there needs to be a lot more attention and care at all levels of it. And as the corporate securities attorney, it's almost, I hate to use the term, but like a jack of all trades, master of none. Everybody on this panel, a fund administrator, the financial experts, immigration lawyers, everybody, the escrow, we have to have an understanding of all of the different issues at all of those levels. Escrow release conditions now under the RIA. We were talking about fund administration and or auditing requirements. We'll probably talk a little bit more about that, I'm sure. The disclosures regarding the RIA that go into a document, we always have immigration matters disclosures, risk factors. So that now needs a whole new eye to be looked at towards under this new law, and what are the issues arising from it. So it's important to really be communicating with all the other experts, at least me from the corporate security side, and putting the package together, because I'm almost in a way telling the story of all of these components that these other folks are the experts in their own right. And so it's a very involved process. And I would say like the biggest thing for me is like communication, talking through issues with all the different professionals, making sure we spot all the issues for all you lawyers out there, like issue spotting, because that final work product really needs to make sure that you're touching all of these issues, saying it the right way, the client understands it, and it's, and we understand it needs to be marketable, saleable in the marketplace and everything. So it's a lot of things at once at every different level, making sure everything, you're capturing all the right things in order to be compliant with the, most importantly now, the RIA. And there's other specific components too, I've mentioned, and we may talk about more, the fee disclosures and agents and sub-agents. There were some discussions about that on earlier panels. So crafting that language in an offering package, in a subscription agreement or an addendum to the subscription agreement, some disclosure document that you need an investor to sign that they read and understood that we have disclosed this to you. It's better be as accurate as possible, but sometimes there's unknowns there. So you have to work with the client and other folks to figure out what's the right wording. And we don't have enough forthcoming guidelines, policy guidelines yet from USCIS. So we're kind of in the dark too. So there's a lot of activity, but also a lot of uncertainty, but we have to make decisions.
All right. Well, I'm not going to let you totally off the hook, but I'm going to let you pause and take a breath right now, because that's a great segue into Ron Klasko. When we talk about the RIA and the changes in the industry right now, it's not just about the RIA, is it? We've had litigation recently, and that litigation led to a settlement agreement. And as a result of that settlement agreement, you are now a part of a committee that gets to meet quarterly with USCIS and the other members of your committee to talk about what do we do with the stuff that came out of that settlement and the stuff in the RIA, and how do we operate? So Ron, the burning question is, you've had your first quarterly meeting. Tell us how it went.
It went fine.
And there you have it, the end.
No, here's what I would say. It was, it really was a very collegial meeting. It was not adversarial. It was not us against them. And it really was, the two government lawyers we met with, we're very much interested in hearing thoughts and coming up with solutions. That's the good news. The bad news is there were no real answers that came out of the meeting. So the goal, yeah, and that's understandable. It's the first meeting, we presented the issues. We can't really expect that they're going to have done all the research and to come up with answers. Subsequent to the meeting, we've been submitting, today I submitted 2 position papers on really key issues that are very time sensitive. And so if all of the future meetings are nothing more than collegial, then we're not accomplishing much. But hopefully in the future meetings, we'll have answers to some of the burning questions. What you need to understand when there's a new law, the new law is kind of just the broad parameters. And what we don't have right now are 3 things. We don't have the regulations. Regulations really define the law much more specifically. Right now, the law itself is very ambiguous. We don't even have the USCIS policy, the policy manual. We don't have that. We don't even have final forms. So we're forced to do certain things, but somewhat in the dark. In the coming months, hopefully we will start having flesh on the bones. And a lot of these questions will have answers to. We might not like the answers, but it's a lot better to have answers, even if we don't like them, than to have questions without answers. So that's kind of where we're going. And Jill, as we go on, if we want to get into some of the specific issues from the meeting that are really the hot burning issues, I'm happy to talk about them as we go.
Don't hold back. I think that's what people are here to learn about.
Okay.
So in the meantime, though, let's jump over to someone else and then we'll circle back to those burning issues. Now, John, Ron just mentioned that we don't even have final forms, but you told us you're out in the market selling offerings. What forms are you using?
Well, happily, it's only the promoter forms that were submitted as draft. We're using the ones that have been published. And I think, we have to understand that there's real demand in the market. I think we're all seeing that. There's people, it was mentioned earlier that, Latin America has had a lot of change and turnover, that Europe is now in turmoil because of inflation and because of the war in the Ukraine. This is driving people to look for a safe harbor, and that safe harbor is often the US. And having this program back in place, I don't need to explain this to all of you, you know it. So the question becomes to your really specific question, which is, investors also know that there's things being worked out, but they then have to trust that they've got a good team. It's a 5-year investment, right? This isn't a single transaction. And so we talk about our attorneys, we talk about our fund administration, we talk about our escrow bank, and we bring together leading class partners to give confidence that no matter what happens in the roller coaster ride that is EB-5, you have a good team with you for the next 5 to 7 years until you have your immigration benefit and your capital return.
So would it be fair to say that using best practices, you're doing the best you can with what you have today?
Exactly. And I think, building a house on the foundation that is government regulation, it's always shifting. Everyone who works in government sponsored programs knows that things shift and change. And so you have to be reactive, nimble, good partners in order to make sure that you react appropriately.
Excellent. Now, James, one of the things that has been evolving is the use of escrow when it comes to raising EB-5 capital. And you and I worked together years ago when it was a standard practice. It's never been required, for the record. I get asked all the time. Escrow is not required. It's a best practice. But a long time ago, it was viewed as the way to aggregate capital, get it into the country, and it provided some security to the investor that the money wouldn't be spent too soon. Times have changed and money can't sit in escrow for that long.
Right.
And you're hearing lately that people just want to skip escrow altogether. Now, what does that do for the structure of how your bank handles EB-5 money?
Well, it's a good question. I'd say over the last probably now month and a half, I've had decent sized projects come to me with the idea that they want to go directly to the NCE. And unfortunately, from a bank of our size and kind of status within EB-5 marketplace, we're not built to go that route. Right? We build policies and procedures to help the projects that are out at market really be able to be confident that as another part of their team, whether they have, great third-party administrators, attorneys working for them, broker dealers, that we can be, a really solid piece, not just from their marketing perspective, but from a confidence perspective to their investors that they can hand down, right? You're working with a bank that has, history with escrow in a very complex space, right? This is not an easy thing to navigate. Jill, you and I and, Ronnie, Rohit, Jay, like, we all worked countless hours together to come up with the best language we think is available for escrow documents right now. And I know Ozzy can attest to this. If you've worked with us recently, I must have sent him 3 or 4 different versions of drafts and things that we've gone through. I think it provides a big level, not just of security, but of understanding that the folks that are out there raising money, they know what they're doing because they have this very detailed team, kind of working along with them.
So using an escrow is not about holding money for a length of time.
No, not anymore. No.
It's no secret that many banks in the United States won't receive EB-5 dollars at all. So what is it that Signature is doing while the money goes into an escrow account that's different than if it just went to a checking account?
Sure, I appreciate the follow-up question. Checks and procedures, OFAC checks, negative news, things of that nature, going through escrow, it allows a regional center to have a little bit more time, and bank as well, to be able to vet those investors, right? That the money's not just coming in and going directly into the US monetary system, not a lot of checks being done on the investors themselves. When you go directly to NCE, if that's your market, great. We wish you the best of luck with it. What happens is a lot of times it's banks that are not familiar with EB-5 that are taking those types of accounts, and they're not escrow accounts, right? There'll be general checking accounts. That money comes right in, it goes right out. The biggest fear that we've heard in the market is how is that going to affect, or will that affect my raise 6 months, 8 months, a year from now, if the bank that I'm working with, they're not using escrow, they're allowing me to go directly to this account. How is that going to affect my raise if in 6 or 8 months from now, they see all this money coming in from overseas and they have no idea what it is? How is it being used? What are the provisions around these investors? And if that happens, that they're going to put a hold on your account, likely. That's going to cause great headache for those out there in the market raising money, into a vehicle that is not meant to handle that type of money.
That's exactly what I was looking for. So short version of the story is if the bank can't do its due diligence, it can't accept the money, and it either gets returned to the investor to start over, or you're left finding a new bank to hold your money and you're stuck in limbo.
Yeah, because then it comes into document changes, amendments, notifications, everything that you guys out there raising capital don't want to have to do. Those are potential headaches by going certain routes, for sure.
Thank you. So Ron, one of the burning questions I have, and hopefully it's something that your group is discussing in your quarterly meetings, will the RIA requirements apply to pre-RIA offerings?
I can tell you that seems to be unresolved at the Immigration Service, even at this late date. Our position certainly that I told you we did 2 position papers. The third one will be on that subject later this week. But we believe it's clear enough under the law that the RIA provision should not apply retroactively to projects, many of which may be winding down, may have a few investors left. The concept that somehow, a 6-year-old project where the money's already been spent should have a fund administrator and an audit when all of the funds have been budgeted and projects put together based on a budget. It makes no sense policy-wise, and we believe under the language of the RIA, it makes no sense legally. But I can tell you that's not a completely resolved issue.
So as an attorney advising clients who may be in the industry right now and may have been pre-RIA, from a best practices perspective, do you tell them to go ahead and comply, or do you tell them they don't have to?
Yeah, it's a really good question. And I explain exactly what I just explained, that it's not clear. I do say that in my legal opinion, that it should not be applying. I really think it won't end up applying, but I'm not certain. And there's not much you can do. I mean, think about it. There's time limits, right? That, the fund administrator must be brought in within a certain time limit. Well, that's long expired. That may have expired 7 years ago. So a lot of this you can't comply with on a timely basis. If somehow the Immigration Service says, we've decided that it does apply, then they would have to provide, okay, now you have 60 days to do this going forward, would be the only way they could do it. So I am not, at this point, advising my clients that they're legally required to do that.
Okay,
Isn't it almost similar to like the decertification of all regional centers? Like when that came down, it's like, it doesn't even make any sense. And they ended up having to figure out through a settlement and everything, but I don't know if that's precedent for this, but it follows the same counterintuitive concern.
Yeah, there's a lot of law on retroactive application. We actually used this in the litigation we did on the redeployment, when they came out with redeployment is limited to a certain geography. We argued retroactivity on that. There's a lot of law that says generally you can't take the law and apply it retroactively to the detriment of the regulated public. So I don't think I hope we're not going to go there.
Yeah.
But it's, certainly one of many important issues that it would be really nice to get something in writing from the government that they agree with that.
thank you. David, you're awfully quiet down there. Let me bring you into this conversation. So the RIA put in a requirement that all regional centers have to retain the services of a third-party fund administrator. But they followed with 2 exceptions, and someone may possibly not be required to have a fund administrator if they employ an RIA. And they're for sure to have an exception if they do audits. Now, one question that I get asked on a very regular basis is, if I choose to have an audit, does that apply to the NCE and JCE or just NCE? And if so, what does that audit look like and how much does it cost?
Well, first question you have to ask is, are you ready to conduct an audit? Because it's not as though you can call a CPA firm, they're going to walk in there and the next day they're going to produce an audit report, because there is a level of independence that's required to prepare a financial statement by a CPA firm. So this is going to require have the internal structure in place that's able to generate the financial information that is in shape to conduct an audit. So the general cost of doing like an audit for an NCE should not be terribly expensive. I would probably say that it's more about being ready internally to produce the information so the audit can be conducted. I would also say that we used the term getting an audit done I kind of loosely today, and I think that there's a lot of advantages of having an audit done, mainly because it provides a level of independence, it provides integrity to the operations of both the NCE and the JCE. But keep in mind that you have to also plan to get an audit done. There can be certain things that, and I can think of 3 things offhand that should be examined. One is, for example, has the NCE paid all of its withholding taxes properly on the income it's collected with respect to its foreign investors? And if they have not, then that is going to be a liability disclosure on the financial statements. And those are things that need to be cleaned up before you start conducting an audit. And what I often see from representing many NCEs is they totally forget about state withholding taxes. So if you have a loan to a jurisdiction like in California, there's withholding taxes. And if they didn't pay them in, this is a liability disclosure. The second thing to keep in mind is that the auditors are required to examine the receivable, the loan on the NCE, and whether or not it's fully collectible, and whether or not to have to reserve for it, and whether or not there's sufficient collateral. So those are something else that you have to take into consideration, kind of examine, because the auditors are going to follow the regulatory requirements. And if you're going to reserve for this, that's also going to be a concern. The third thing I would say with respect to the NCE and JCE, that if we're dealing dealing with common control, I would probably tell you that both entities would be required to be audited. And obviously, if you're dealing with the JCE, that's going to be obviously a larger cost than just dealing with the NCE.
So David, is it fair to say that there is an additional cost above just getting a quote for a simple audit, both financially and reputationally, as it relates to doing this NCE audit?
Well, again, anytime you're doing a first year audit, the best thing to do is plan. It's not something that you can rush into and snap your fingers and assume it's going to get done overnight. You really need to make sure that internally you're ready to conduct the audit, and you really have to look at these items I'm talking about to make sure that what you're reducing in terms of financial statement is what you want to reduce. And obviously those are the things that need to be examined and cleaned up amongst other things before you start issuing financial statements.
So not a slam dunk substitution.
No.
Okay.
But it's definitely, you know, from the standpoint of having an independent CPA firm issue financial statements, it has enormous credibility to the investors, especially the ones that we're talking today, that are very sophisticated. They're putting an awful lot of money into these projects. And even though these are historical, it adds a lot of credibility.
I think that's an excellent point, and I don't want that to be lost. There's no one on this panel that would say having an audit wasn't best practices. I think it should be a given, but I don't think it should replace the role of the fund administrator. Back to you, James. The fund administrator has a new duty now under the RIA to be a co-signatory. You and I spent a lot of time figuring out how the bank could actually enforce a co-signatory role. Can you explain a little bit about what the bank has to do actually to be an enforcer of a true co-signatory versus a joint account?
Yeah, I mean, without giving up, I don't think there's any other bankers in the room, so I think I'm in a safe space, but no, there was a lot of hoops to jump through because there has to be a better understanding of who's playing what role, where do they have ownership, you know, what requirements are there, what type of authorities are we giving? And if there's no ownership inside of certain documentation, it becomes a little bit more difficult from a bank to allow just anybody to do very specific things like what is being called for in legislation, the settlement, and so forth. It took a while, I'm not going to lie. It took a lot of conversations, internal, external, to finalize who was going to do what. And in the spirit of the business that we find ourselves in now, how can we put the best product forward so that you can go out there and raise confidently? The fund administrator can be exactly where they need to be on set accounts to make sure that they are following the letter of the law, essentially, that comes down, right? I mean, obviously with separate accounts, there's the conversation about who has to be where. Are you opening second accounts for operating expenses? Who has to be on those? All the way down to the JCE. So I know, Jill, you and I have had conversations from the fund administrator side. Is it easier to have everything housed together from a tracking, obviously from a bank that's great to be able to hold more, but how does it help the project in the event that there's reporting that needs to be done, or there's additional communications when it's time to produce, said documents? Is it easy to get? So I just think in the spirit of what the RIA has put out, working closely with you guys, I think we are in a very comfortable position to be able to continue on the way we have. We got our bank, our compliance, our legal team to understand what the new requirements are, and a testament to working, very closely with Jill. She had many conversations with our counsel to put this into place. And I think you would agree. I think we're in a pretty good space on how to operate when it comes to having the third-party administrator or the fund administrator on there.
Well, let me just throw a cautionary tale to the room. The reason I'm pressing James on this issue, and the reason that we're so thrilled that Signature Bank does have a solution, is now that having a fund administrator co-signatory is required, we have had many conversations with other banks that our clients have had relationships with for many years, say, sure, we can do co-signatory, no problem. We'll just put you on a signature card. But as we pressed into those conversations and we worked with setting up the process, what we discovered is those banks can't enforce it. So while they say it's a co-signatory and there are two names on the signature card, if one of those names were to call up the bank and ask to move money unilaterally, the bank would do it. So I don't think this is in the spirit of what Congress and what USCIS are looking for in having third-party oversight. If one person can unilaterally move money or one person can unilaterally remove the other from the account, that's not a true co-signatory. And it's a very specialized bank that has the understanding of what EB-5 is and has followed the RIA that can accommodate these sorts of specialized requests.
Yeah, I quickly to your point, Jill, I think having it done the way you're just saying creates a lot of problems. You might not see the problem right away. It might take a year for you to learn that that was a problem, and you don't want that slap on the wrist, I don't think. So yeah, when you're building a team, obviously you're putting together the best possible solutions so you can confidently go to market and confidence is gigantic in this space. I can tell you since we keep talking about, like, is this program alive again right now? We've opened a fair number of projects. I'll go back to June. Probably since June, we've seen just north of about $150 million come in across a handful of projects. So money's out there. People are out there raising. There's ways to disperse. We're very much in the infancy of what this program is meant to be again, but the money's out there. So if you put together a good project, you have good teams around, you can confidently go out and raise money, for sure.
So John, we've talked a lot about financial audits, and David gave us a good description of how to prepare for a financial audit. But in your role, there's a lot of other kinds of audits you need to prepare for. What about an SEC audit? Where does that come in?
Yeah, I think for most of the people in the room, the likelihood of an SEC audit is less. There may be a USCIS audit, and they may do that with SEC teams. In our business, we do have an SEC registered wealth manager, as I mentioned, and so we do have an SEC audit. Anyone who's affiliated with a broker dealer obviously goes through SEC audits. I think stepping back, all of this just talks to the sophistication of the EB-5 product and the step change that's happened. We're starting to talk and sound like classic private equity and US-based Reg D regulated private equity. And that's a good thing. So it means that all of us, we can't just be small businesses hustle. We have to act like large business with disciplined processes, good record keeping, and good partners to make sure that you're in line with the law.
I think that's a perfect answer. Thank you for that. Yes. Jay, I gave you a break. I'm going to bring you back in now. We talked about how things are still fluid. So we're waiting for regulations from USCIS. We're waiting to see what comes of the settlement quarterly meetings. As you're drafting documents now, doesn't that leave you a lot of what ifs and make your offering document about 3 times as long so you can cover all the bases?
For sure. I think, one thing lawyers are good at is overanalyzing. And so we kind of beat a dead horse on all of the components, like I was saying before, working with our immigration professionals, whoever we're working with, escrow agents, fund administrator, escrow administrator, everybody to figure out crafting the appropriate language. And deal after each deal, it always evolves a little bit. And certainly every deal is tailored, the docs are tailored to that specific deal. But even the concepts, one escrow release condition of the 3 or 5 of them or whatnot is evolving itself because we're getting more feedback, more information. USCIS issues some receipt letter or a letter from you. It doesn't look like a 797. It's something that shows, or they've taken your money, like all these different things. So we're now adding language to cover. Well, what if that, would that satisfy this release condition that USCIS has accepted a 526E or whatnot? So things like that, I guess it's twofold. One is crafting the right language and just overanalyzing, working with the right professional and getting alignment on really what's the best industry standard language, disclosure, what have you, at the time, at the moment for that deal. And then I think number two is because we're still waiting for this, forthcoming policy guidelines or what have you, having the appropriate risk factors, qualifiers, sometimes in repetition in, a PPM, but in the other ancillary offering docs, the regional center sponsorship agreement, all those things where you have to cover the idea that there's so much uncertainty, like we've already been talking about before, and Ron was saying before. And so we do have that language. So first, we're getting as best as we can with the language and what we believe is the path, the release condition, or the disclosure, the fee disclosure, and then addressing the uncertainty as an issue itself throughout all the documents appropriately, and sometimes more than once, because it's important. We're always worried about a denial, an RFE, or even possibly a denial. And what if we're in front of a judge too, just on general disclosure concerns and corporate fiduciary obligations, securities compliance generally? That's the hat we're always wearing and the question mark we always have at every level.
And David, you talked about folks that may not have planned appropriately for their audits. And one of the issues was not withholding state taxes. What are some of the other mistakes you've seen, and what are the results of those mistakes?
Well, typically in my involvement in working with NCEs, some of the biggest issues that I see are the failure to record keep properly, to make a determination as to the proper amounts of withholding taxes. And this is a very time-intensive work that has to be done because there's many different set of rules, because when your investors come into the NCE, they may initially be non-residents for income tax purposes, and then they become residents for income tax purposes. So the forms that you're going to be required to obtain in the monitoring of this and withholding tax issues are going to be vastly different. And when you're dealing with non-resident investors from countries in which we have treaties, then your withholding taxes on the interest income will be different, it could be reduced. And then when you're dealing with various states, if you're dealing with non-residents versus tax residents in the US that are residents of that state or non-residents of that state, there's a whole separate set of different withholding rules. And really internally, this is a type of documentation that has to be managed. And it's very time intensive. The one thing that's one area. The other area that I've seen is the different tax positions that NCs are taking on the preparation of the returns. Sometimes I see that they are treating them like businesses where the interest income coming in is being entirely offset against expenses. I don't believe that's appropriate. They're treating them like businesses. These are typically investment partnerships, and the expenses under current tax laws are not deductible, and withholding is on the gross amount. So it's really important that you properly plan for that. And one area of planning is to look at the portfolio loan rules to avoid the withholding taxes on the gross interest that's being collected.
Ronnie, you had a question.
Yeah, this is for David.
There's a mic right there.
Thank you for David in the audience. This is very interesting. David and I have we first went to China in 2011. That's the RIA tax conference. And I remember I have a very funny story. Somebody said, gee, you come to the United States, you have to pay tax on your worldwide income. And I said, yeah, welcome to America. I remember that comment. So the issue is David has concluded from a pure tax point of view that if you have a U.S. entity that is not in a trader business, but is just making a loan and is not a trader business, you don't check the wrong box, and the investors are foreign, the foreigners take on the character, the lender takes on the characteristics of the foreign investors. If you're a foreign lender that owns less than 10% equity in a project, this is under 871H of the Internal Revenue Code, your interest is exempt. It's exempt. You don't even have to report it. It's exempt. So a lot of people, David and I have gone back with a lot of our clients and read on documents. You have to put them in your documents. You have to register. You have to have an affidavit from the lender. But really, it's a great planning tool. We've done that with several of our clients. We've come back and cleaned this up. So you can avoid a lot of the reporting and the headache of having a tiny bit of income or allocable income of distribution and then have to file, tax returns for, 200 people on a, $100 million deal. That's expensive. So maybe you want to comment on that.
Yeah, one of the things I've seen,
Sorry about that.
one of the things I've seen is that the big problems with these NCEs is that when treat them as though they're businesses. And you have 200 investors, all 200 investors are required to file tax returns in the US. And that is ridiculous. So what we do is we treat them as though they're investment partnerships. And to the extent that there's requirement to withhold, the foreign investors have no other US tax filing obligations whatsoever, as long as it's proper withholding. And we tend to take it one step further, as Ronnie said, and we take in consideration some special internal revenue code rules that allow, to the extent that there's proper loan documentation drafted by the attorneys, and we have the right IRS forms from our investors in the file, that there is no federal withholding requirements. I can't say specifically whether it will be state withholding, but I think that from a federal perspective, it's fantastic because your foreign investors don't have to file tax returns and there's no withholding, which means that when you have all these expenses going on, you're able to actually save some taxes so that effectively you can pay for all of these new administrative costs that have to take place. But I've had to go back and amend years and years of NC tax returns because the investors were sitting there going, why do I have to file a tax return for the last several years? And the withholding taxes were completely computed under a different method. And in some cases, it actually exceeded what it should have been. So there's a lot of liability exposure for the managers of these NCEs. And obviously, as I said earlier, from financial statement audit perspective, this is one of the areas that has to be examined and cleaned up because these are the types of things that get disclosed on the financial statements.
Thanks, David. I don't want to get too far to the end of our presentation without giving Ron a chance to talk about some more hot issues. What are some more of the hot issues coming out of your quarterly meetings?
Yeah, one of the most time sensitive issues, and I know this affects the number of my clients, some of you in the room, is there are regional centers that for various reasons will not want to file an I-956. They're not going to have any new projects, they're not going to have any new investors, but they certainly want to, to continue their sponsorship obligations on projects that they did pre-RIA. Is that a problem if they don't file a 956? The answer is it shouldn't be. The Immigration Service has not decided whether they plan to terminate every regional center that does not file a 956. This is a subject of discussion. We have strongly advocated, and we need an answer to this real quickly, that both under the RIA, under the language of the settlement agreement, which spells out if you don't file a 956, you can't do new projects. It doesn't say you're going to get terminated. So first issue is, will they terminate the regional center? Important issue. Secondly, if they don't terminate the regional center, is there still an annual filing requirement for those regional centers? It would be counterintuitive that before the RIA and all the investor protections, you had to file an annual statement, but now you don't. Fair question. Third issue, if you have to file an annual statement, what form do you use? It doesn't make sense to use the I-956G that does not apply to regional centers that don't file 956s, that are never going to have 956F. So maybe it could be the 924A or something else. So one of our position papers, Jill, covers those issues in some detail, advocating that such regional centers that don't file 956s should be allowed to wind down, continue in existence, perform their previous regional center obligations. It does seem perfectly appropriate that they file an annual statement, but it does not seem appropriate that they file an I-956G. The last issue I'll mention that we submitted a position paper on is, and this is, I'm not anticipating that the government's gonna agree with this, but I think there is a real logic to it, and we did discuss everybody's laugh test. It doesn't make any sense for I-956Gs to be filed this year. What's going on here, right? We have 400 to 600 regional centers are gonna file 956s by December 29th. The concept that those 400 to 600 regional centers also have to file 956Gs by December 29th. In what decade are they going to look at all these documents? The I-956G has a cutoff date of September 30. You're only reporting through September 30. The program really wasn't implemented until the judge signed the settlement agreement on September 1st. So you're really, there was no activity before that. So you're really reporting on what happened between September 1st and September 30. And remember, all the regional centers filed the 924A annual statements in December of 21 when they were supposed to be put out of business, according to the Immigration Service. So they have all of that information already. So we believe it is very reasonable, both in terms of the burden on the government to look at this stuff and the burden on the regulated community to submit all this stuff to delay the 956G requirement until December 29th of 2023. Now, am I advising my clients not to file? No, of course not. However, remember that, let's talk about just a second where we are in these forms. So all of these forms, including the G, are legal forms. They're what's called interim final forms, legal. However, they're temporary. And the part of the settlement agreement was that the government will accept comments and have until December 1st to make any appropriate changes to the form before they become final. So it may well be, because I know we and others submitted very substantial comments on the G form, that both the instructions and the form itself may change before December 29th. So if we don't even know the form yet, we don't know whether regional centers that are not filing 956s have to file it. We don't know whether it applies to pre-RIA projects. The RIA, RIA applies to pre. We have all these open issues, and we're reporting on a 1-month period. At the same time as we're filing 956s, we felt it was reasonable to discuss the fact that maybe they shouldn't require it.
So Ron, how do you, what do you
Ron,
do?
grab the mic real quick.
I did last time and blew it apart. What do you do now? You have an existing regional center that doesn't want to do new projects. You don't want to screw your investors. You wait till December 1st and see what they say. What do you do? You have till December 29th.
I have a lot of these situations.
What do you do?
So as of right now, if in most cases, if we don't get an answer from the Immigration Service on a timely enough basis, I'm suggesting that you should file a 956, because if you don't, Ronald, and if they do in fact terminate, then a spiral of events occur. The Immigration Service says a termination of a regional center is a material change that can result in the denial of grandfathered investors. All right, but then you say, well, there's the good faith investor provision in the RIA that says that if the project associates with a new regional center within 180 days after the termination, then the investors are saved. But there's at least a minor problem with that. What regional center in the audience wants to take on a project that was completed 5 years ago, and for which there's no new money coming in? Probably none. So therefore, you may not be able to find a new regional center to take on the project, which would mean that these grandfathered investors who are protected under the RIA would end up being denied, which makes no sense, because when they took the position before the litigation, I'm sorry for playing lawyer, I get carried away with stuff. When they took the position prior to litigation that all regional centers were out of business, they still were approving 526s because the RIA required them to do that. So they're in a conundrum. And we're trying to help them. We are trying to help them out of the conundrum, because we're here to serve.
I have to be very clear. We don't include this in our investor presentations.
Ron, December 1 comes, you're out of your advice.
Yeah, my advice is, yeah, I mean, there's regional centers who do not want to do new projects. I mean, it's more than a minor decision. There's integrity fees. There's, responsibilities to, maybe responsibilities that fund administrators and auditors. There's all sorts of obligations. There's all sorts of new liabilities attached to being a regional center under the RIA. A lot of us think that's a good thing, and I do, but these regional centers may be, may have multiple projects and no staff to really.
And no money coming.
Yeah.
And they can't afford to do all this stuff. They just want to get out, but stay compliant.
But they don't want their investors
Their
to lose out.
investors, yeah.
So it really is a difficult issue. And in some cases, what regional centers that don't want to continue to do business, may choose to seek to be sold.
Well, Ron, I had a question for you, sorry. Then why so many people trying to find regional centers and they can't find them to buy them? Based on what you're saying, it means everyone wants to sell, but everyone's calling me for a regional center.
Yeah, because.
So
if
they're
you
in high
want-
demand,
Yeah,
actually.
so if you're a project and you want to, get started raising funds by 956F, well, you have to file 956 first. If you file a 956 first, you're gonna have to live a long life before it's approved and before you can file the 956F. So you have a choice of either finding a regional center to sponsor you, and there's no real place to look for that, or buying an existing regional center. And a number of the projects I work with are in fact looking to buy regional centers. And so if rather than just take the risk of being terminated, maybe you should look for somebody to buy your regional center. These are the kinds of discussions we're having every day in the office.
Okay, I unfortunately have to call us to an end. There is so much more here that these panelists would love to share with you all. So I encourage you to visit with them in our cocktail hour after the next panel. But just a quick summary, since I can't let everyone have another turn. This was the crystal ball session. We have so much uncertainty. Best practices is to do the best you can with what we have today and stay in business. Keep it as close to the rules as you can. And as things evolve, we're going to evolve with them. And thank you all for your time.